everybody, how's it going? It's the Daily Shooter, and this is going to be a California concealed carry update. About 5 minutes ago, I finished watching oral arguments that were presented to the Ninth Circuit Court of Appeals by attorneys for the state of California, as well as interested parties, and attorneys for Peruda, as well as interested parties on the pro-gun side. Now, these oral arguments, they lasted for about an hour and a half, or at least I watched an hour and a half of the presented oral arguments, and I wanted to kind of share with you guys what I saw, what I learned, and what I picked up from each side's argument that was presented. Now, currently, as I'm making this video, the Ninth Circuit Court of Appeals is in recess on this particular issue. So I'm going to go back and make sure that I watch and continue to watch any progress, and I'll bring that to you guys as fast as I can. But here's what I saw. The state of California, who kind of interjected their opinion at the end. If you remember, this case was already ruled on by a 3-judge panel. California decided to interject their opinion at the very end, and the Ninth Circuit Court of Appeals, after some arguments, decided to let them do that. Well, while California was presenting their arguments today in open court, their oral arguments, they were sort of chastised by the court for not having an interest in the case until after it was already settled. So they kind of started off in the back, if you know what I mean. So the court did get on them for, well, why didn't you have an interest? Why didn't you get in on this beforehand? You know, what has changed and what arguments do you have? Well, in doing so, the lawyers for the state of California and Everytown for gun safety and all those anti-gun people basically stated to the courts, and it seemed like maybe they were just really reluctant to do this, but in their argument they stated that it is a fundamental right guaranteed under the Second Amendment for someone to carry a gun outside of the home as it is inside the home. They said to the court, and this, remember, these are the anti-gun people. Now, they did kind of slip when they said this, but they were forced to say it, that it is a fundamental right for you to do so. They just had some issues with that. They had issues with the space that you could carry. So they said it's a fundamental right for you to carry outside the home, but they didn't think you should do it in public spaces, or they didn't think you should do it, and the government should be allowed to regulate in what spaces you could do that. They were saying that already the fundamental right was already being basically lived up to on the state side, because you could carry in your friend's house, or let's say you went to somebody's private property, you could carry on their private property, which is then, you know, considered outside of your home, and the state was using that as their crutch. Now here comes the pro-gun side. This is the lawyers for Peruda. The lawyers for Peruda stood up and had fantastic arguments. If you ask me, they hit several different points, and they were pressured by the court to prove each point that they were trying to make. The court did not back down on the pro-gun side as much as they didn't on the anti-gun side, but the pro-gun side really held up much better than the state did. Okay, we had better arguments, better facts, better legislative records from other courts than the state did. The state basically only had an affidavit from a professor stating that it's too dangerous for you to carry a gun in public, basically, is what they're saying. Now, the problem is that the court recognized the fact that in California, for the most part, you cannot open carry a loaded firearm, or basically at this point a firearm at all, in most counties, as well as not concealed carry in most counties. That changes the fundamental right of the Second Amendment to protect me outside of my home, and the court almost openly recognized that. They recognized that there was an issue, that you should at least be able to carry one or the other. Now, they didn't say that outright, but that's what I picked up, and this is just my personal opinion, but this is what I picked up from the court. Okay, so this is very important, and the way that I see it right now, the court seems to be leaning towards the pro-gun side, the pro-carry side. Now, I'm not sure if this is going to turn out to be something that is pro-concealed carry, because I did notice there was a little bit of hesitation for people, judges on the court, to kind of openly accept the arguments for concealed carry, because they we're sort of talking as if, as long as open carry was available, would you still need concealed carry, to where it had to be contended by those who were pro-gun that, okay, no, if we were allowed to open carry, then this wouldn't be such the argument. The argument is that with that, you know, clause in the law currently, we can't do either open or concealed. So anyway, they're in recess right now. It looks to me like this is going towards our side of the law. So let's pay close attention to this one. Stay tuned. I'll post as many videos and updates as I can. Thank you guys very much for watching. Please like, subscribe. You guys have a great day.